Hello, thanks for joining us for this third webinar in our rendezvous series on the Digital Markets Act and Digital Services Act. I'm Lara Natale, CERRE's Tech, Media, Telecom and Mobility Director, and your facilitator for today's debate focusing on institutional design and enforcement methods in the Digital Markets Act, the DMA. As the independent Brussels-based think tank promoting top quality regulation practices in Europe, CERRE has been keeping pace with the fast-moving legislative train on the DMA. So CERRE published its DMA recommendations in November. After the Commission adopted its proposal in December, our academic team published initial reflections in the form of a paper, which we launched at the occasion of our first webinar in this series back in mid-January. In February, we talked about prohibitions and obligations, and as for March, well, here we are today, and we're very lucky to have a jam-packed agenda, and we have much to cover in the next 90 minutes. So I have my work cut out to keep pace indeed. We'll be starting with Giorgio Monti, Professor of Competition Law at Tilburg Law School and part of the CERRE DMA academic team, who will outline both the CERRE team and his own views on institutional design and enforcement methods for the DMA. Then, for the first time in this webinar series, we're delighted to be hearing from the European Commission. So a warm welcome to Thomas Kramler, Head of Units for E-Commerce and Data Economy at DG Competition. The transatlantic perspective that has become a series signature is provided today by Filippo Lancieri, Stigler Center Research Fellow at the University of Chicago's Rosen School of Business. Our national regulatory body representative will be from Arcep. Our industry representatives are from Deutsche, Telekom and Facebook. I'll be sure to fully introduce everyone when we open the panel. Then in that panel, we'll discuss key questions on institutional design and enforcement methods, as we see that DMA gives rise to many issues in this area. But as always, we're keen to make space really for a variety of further questions from you, those of you watching with us, and you can submit these via the Slido using the hashtag CERREDMA or scanning the QR code that appears on screen, and I'll take questions whenever possible during the discussion. Lastly, we warmly encourage you to sign up to the free CERRE newsletter, details in the box below if you're following on YouTube or on CERRE's website, cerre.eu. So moving swiftly onto the substance of this discussion, Giorgio, it's great to have you with us. This rounds off, in fact, the appearances from the CERRE academic team behind the recommendations in this event series. We know that you'll be outlining comprehensively how the CERRE team approach the question of institutional design and enforcement methods, and you yourself in a personal capacity have done a lot of work on this, so you have the floor.
Thank you very much, Lara, and it's a pleasure to be here, and I'm looking forward to the discussion. I'm going to make 6 general observations about how the DMA is designed and outline a little bit the position that CERRE adopted in its initial reflections on this, and add to these a few of my own views that have emerged since studying the DMA a little bit more closely. The first point to observe is that the Commission has centralized enforcement in its hands, so it's a one-stop shop approach. National competition authorities or other national regulators are not foreseen to have a major role in this. To a certain extent, I think this is a good development. I'm not so sure that national competition authorities would have the capacity necessarily to handle these large players. It's also difficult to see what sort of incentive one could give the national authorities if their sole role is one to report back to the Commission any teething problems they observe in their national territory. Centralizing it with the Commission also allows the Commission to learn across the various dossiers, and we're not likely to see a huge number of gatekeepers being regulated. So the estimate is 10 to 15. It doesn't seem like one needs to decentralize enforcement to deal with such a small number of players. My second point relates to what is referred to in the DMA as a regulatory dialogue, and this is provided for in Article 7. I think this regulatory dialogue is promising, but could be refined in the legislative process. The position we put forward in CERRE is that it would be preferable to have a compulsory notification procedure whereby the parties reflect upon how they wish to comply within a few months and then notify the Commission of this. And then a regulatory dialogue can commence. At the moment, the regulatory dialogue is reactive. Either the Commission considers there is a problem, or the parties can voluntarily ask the Commission to take a view. It might just be preferable to have a notification stroke exemption system. When the regulatory dialogue commences, the question then arises whether this is a dialogue just between the parties and the Commission, or whether it's a broader conversation with other stakeholders. So commitment decisions are hinted at in the DMA. In commitment decisions, we have a market test where other people are involved in the regulatory design. The more people are involved, the more the obligations can be fine-tuned, and the more one can observe the principle of proportionality to ensure that the regulations go no further than necessary to resolve the market failure. My third point relates to what I refer as the enforcement pyramid. So this is a technical term used in the regulation literature where the regulator begins at the bottom of a pyramid with the assumption that most parties will want to comply with the law, and then escalates upwards with more and more severe punitive measures if the firms do not comply. Now, to a certain extent, the DMA is designed in this way. The pyramid begins at Article 7. The parties should voluntarily comply. If there's no compliance, the Commission can initiate proceedings under Article 7. Then you escalate to non-compliance, and then to systematic non-compliance. So the steps in the pyramid are there, but there may be too many steps in the base. That is to say, in Article 7, if the Commission objects to the proposal, it may then issue a unilateral remedy, whereas I would argue for a more consensual settlement under Article 7, and then moving to more punitive measures only in cases of non-compliance and systemic non-compliance, so that the commitment procedure is fully engaged in Article 7 as the default mode of operation. The fourth point is about updating the obligations. I think it's tried to say that digital markets move fast, and so the designation of gatekeepers may be under-inclusive, the list of obligations may be over-inclusive or under-inclusive, and so some modifications need to be made. These require a market investigation, which lasts about 24 months. And subsequent to that, to add obligations, one can use delegated legislation, which can be relatively fast, but to add another core platform, one needs to amend the regulation, which can take quite some time. So the question arises whether updating the system can be made any quicker. I note that interim measures cannot be used as a way of updating the system because one can only impose interim measures on the basis of existing gatekeepers' obligations and not to extend these obligations. Now, looking at the recital of the DMA, there is a reluctance on part of the proposal to allow for a quick modification because the recitals provide that one needs to provide a close assessment of each practice before being certain that something can be blacklisted. But this can really make the process a little bit slower. And the question then arises whether necessarily competition law would have to come in and apply if it is felt that the regulatory framework is under-inclusive. Another recommendation we made in the CERRE paper is to include a sunset clause. It might be that some of the obligations are perceived to be necessary today, but as the markets develop, these are no longer necessary. It would be consistent with the principle of proportionality if obligations were removed as well as included, as added to. The fifth point is about the role of private enforcement. I think this is necessary and should be specified in the DMA. This is specified, for example, in the P2B fairness regulation, of which the DMA is maybe the bigger brother. And there, the regulation does specify that national courts should provide effective remedies to aggrieved parties. Now, it is true that not all businesses will want to use the legal order to challenge infringements of the regulation. Some may fear retaliation, some may prefer an informal approach. We've seen these in many studies on B2B relations. Nevertheless, some parties may feel that it is worth their while to seek a remedy, an injunction to force the parties to comply or damages. And I think enshrining this in the regulation would just remind everybody of the right to damages. And this is purely consistent with EU law that enforcement is decentralized to private attorneys general. My sixth and final point is the relationship between the DMA and competition law. I think the DMA does this correctly in the recital in suggesting that there can be parallel application because the two cover different interests. But one thing that could become awkward is whether national competition authorities might wish to use competition law to upgrade the obligations that are imposed in Articles 5 and 6. So suppose a national competition authority feels that the obligations do not go far enough to resolve a market failure, then they can use competition law to say, we would like to impose additional remedies in order to ensure the market functions well. So this is a bit the reverse of what happened in Deutsche Telekom, where the Commission intervened after it was dissatisfied with the regulatory approach. Here, dissatisfaction with the Commission's regulatory approach might tempt others to use competition policy. And I've suggested before, also in adding new obligations, that there may be the consequence of the updating being slow might be that then competition policy is used as an indirect way to upgrade obligations pending perhaps a market study. Other than that, we think this is an important contribution to the discussion. We think the DMA is wisely designed in terms of its structure, and particularly the idea of pushing a regulatory dialogue is extraordinarily valuable and should be developed further. For now, I'll stop here. Thank you.
Thank you, Giorgio. I think this is really brought out very strongly something that's come up in the other webinars to date, which is the importance, as we see it, of the DMA being a nimble, responsive instrument. You made many points about upgrading or downgrading, let's say, lists of obligations and sort of thinking about the instrument and its evolution in an ongoing way. Thank you very much. And I think that set the scene really well for us hearing from the Commission. Thomas Kramler, thank you so much for taking the time to join us today. This session really will benefit enormously from understanding firsthand where the Commission is coming from on institutional design and enforcement methods, and it's going to be very useful for the endeavours of all of us thinking about this policy area over the period ahead, to hear from you and how you envision the more centralised institutional design. Over to you.
Thanks very much, and good afternoon, everybody. I'm very glad that this panel actually focuses on enforcement, because this is often neglected. And I think some criticism has been waged towards EU legislation that we don't emphasize enough the enforcement of the rules once they're in place. So it's very good to discuss about these, and the rules can only be as good as the enforcement is in the end. So it's very important that we put an emphasis on enforcement, so it comes very timely, this discussion. What I want to discuss is three issues that Giorgio already mentioned. So why did we opt in the proposal for central enforcement? Why do we think this is the right way to go about it in the DMA? The investigatory powers that the Commission or the enforcer will have under the DMA, and the complementarity to competition law, and how the two sets of rules will play out in practice. So let me start with some comments on why we opted for centralized enforcement through the Commission. The proposal is an internal market proposal. It's based on Article 114, so an internal market legal base. Its main aim, therefore, is also to harmonize the different approaches in the different member states. We know that many gatekeepers throughout the EU have a common business model that they want to roll out in all of the member states. They don't want to have differences in their business model, in their approaches regarding different member states. So from an internal market perspective, we think it's very important that there's one clear set of rules which applies throughout the internal market, and to which gatekeepers can also adapt in terms of adapting their business model to the regulatory framework. We want to avoid divergent interpretation of the rules in different member states by different authorities. I think we should learn from experiences with other enforcement regimes that have been put in place, where the enforcement was entrusted to 27 different regulators, and that might lead to diverse problems like forum shopping. Who is the right agency that should deal with a specific company? Should it be the agency where the company has its establishment? Should it be the agency where the conduct mainly takes place? All of this can be avoided if there's a centralized authority which enforces the decisions in a centralized way. There's one interpretation of the rules. There's no divergence. That creates legal certainty. So we see a lot of benefit in a centralized system. Let's also not forget, as George already said, that this is asymmetric regulation. So we will have only a handful of companies, gatekeeper companies, which will be subject to these rules. They will be big conglomerate companies, mainly if you look into the criteria that Article 3 sets for designating a gatekeeper. So companies that will have an impact on the single market, that will operate on an EU-wide basis. And therefore, we think that it makes more sense to have a centralized decision-making body. This does, however, not mean that there won't be any interaction with national regulatory authorities, national competition authorities, and national data protection authorities, because all of those, if you just look at the list of obligations in Articles 5 and 6, you will see that there will be a lot of interplay needed, for instance, with the data protection authorities, because very often the obligations refer to concepts that stem from the GDPR, for instance, which would need to be interpreted in line with the GDPR. So there is certainly a need for intensive interaction with national authorities, especially those who have specific knowledge in specific sectors in order to come to the best results. Obviously, there's also a place for private enforcement, as Giorgio already mentioned, and one of the reasons why private enforcement is actually or can actually be implemented through the DMA is that the provisions at least in Article 5 and to a large extent also in Article 6 are self-executing. So the clearer the provisions are, the easier it will be for them to be enforced privately in member states' courts, obviously with the benefit that uniform application can be ensured in the end by the ECJ through preliminary rulings. So this is to say that we still believe that centralized enforcement is the better approach in the DMA instead of decentralized enforcement through 27 different agencies. However, and that's probably an area where discussion still needs to take place, how member states authorities, the different authorities, not only competition authorities, but also regulatory authorities, telecom regulators, for instance, or data protection authorities can be involved, how information exchange can be ensured between these authorities. That's something I think where the DMA could certainly still be improved, and that's already a big debate in Council and the Parliament on how to better ensure that there's a broad basis of knowledge that can be shared amongst the different authorities. Let me now talk about investigatory powers for a while, because obviously this is also very important. It's often neglected in discussions. There's a huge chapter on investigatory powers of the Commission in the DMA. It's obviously modeled along the lines of the competition powers in Regulation 1/2003, but it has some add-ons which are important and which should give more teeth, if I may say so, to the DMA. There's Article 19, for instance, which allows the Commission to access databases and algorithms, which will be important in these markets. There's Article 21, which allows on-site inspections and dialogue with the company on site and explanations to be given by the gatekeepers on site, which is also something in a less contentious way, I would say, than with inspections under competition law. So more framed in terms of a dialogue instead of an action which basically, like an inspection, which basically is a contradictory process. Here, the Article 21 sets this more up as a dialogue on site. Then there's Article 24, which allows the Commission to hire experts, and that will be certainly necessary in many areas, as some of the obligations and the implementation of which is going to be very technical, especially if you think about interoperability obligations, data portability obligations. There will be discussions about standardization, for instance, and technical expertise will be needed. And the Commission will therefore need to rely on technical experts in order to get the required knowledge on board. And then there's the market investigation, which is an interesting tool which makes this DMA in a way future-proof and more attuned to business realities for those markets where we cannot yet, for instance, identify which kind of obligations they would be necessary. So there's Article 17, which allows for market investigation into new services. This gives the necessary flexibility to the tool, not to be behind the curve in a way, so to be updated. Obviously, as Giorgio mentioned, this only applies to new obligations. It cannot apply, but that's more for institutional reasons, cannot really apply to updating the core platform services because that would go to the core of the Act, and the delegated acts can only cannot change the core of a regulation. So there's a bit of an institutional issue with the use of delegated acts, obviously. So market investigation, a very powerful tool that I think makes a lot of sense. It's modeled a bit along the lines of what the CMA has in terms of market investigation powers, which have proven in the past to be very useful and to come up with very powerful remedies. Last but not least, let me spend a few words on the interplay between competition law. So one thing I think needs to be stressed upfront: the DMA is not competition law 2.0. It's not an upgrade of competition law. As Giorgio rightly said, it follows a different logic. The logic is that this is a regulatory tool. It's based, as I said, on Article 114. It's not based on the competition law provisions of the treaty. It has as its main goal ensuring fairness and contestability in markets. So it doesn't necessarily have the same goals as competition law enforcement, which is very clear once you read the recitals 9 and 10 in relation to the goals. This is a complementary tool. It's one tool added to the toolbox, which will be applied in complementarity to competition law. It should not replace competition law. It should fill the gaps, I think. That would be one of the reasons for having the DMA, the gaps which competition law cannot totally fill in terms of ensuring contestability of markets, because there's some limits to what can be done under competition law. If you think about interoperability remedies, data portability remedies, these are things which are very difficult to implement under current competition law. So there's a gap filling interest there, and it's also can be implemented side by side. Obviously, in terms of institutional setup, I think it will be important that those who deal with competition law also have a say in when the DMA will be deployed or not, in order to avoid overlaps and to ensure coherence between the two enforcement strands. So as to deploy the right tool at the right moment in time for the right behavior, if I can say so. So institutionally, I think it would be important, but that's what the Commission has in mind, that also those who deal with competition law in the Commission have a say in the implementation of the DMA, together with those who deal, for instance, now with telecom regulation in the Commission. I mean, the Commission has an advantage, and that's my last word on it, in terms of bundling a lot of knowledge in different areas, from consumer protection to GDPR-related issues. A lot of knowledge is already bundled within the services of the Commission, and the advantage of having the Commission as the enforcer of the DMA is also that one can have access to this knowledge, which is scattered, if I may say so, throughout the Commission, and therefore can be made use of for the purposes of implementing the DMA. I think I'll stop here for my first remarks. Happy to continue the discussion in the panel. Thanks.
Thank you, Thomas, and we'll definitely come back to you, as with all speakers in our more interactive panel, in a while. And thank you also for, well, both for highlighting how, as with CERRE, we agree indeed that enforcement is a key area to focus on and not always discussed in great depth in the wider debate, and also on investigatory powers, which we'll definitely come to later in the panel as well. I think one word I'd like to say at this point, you mentioned a lot about the articles that point to a more regular dialogue with authorities. At CERRE, we published last week a paper on new ways of oversight for the digital economy in a much broader way, and we held an event on this where we explored these topics in some depth, and we even looked at how new ways of oversight could be applied within the DMA in terms of what principles to look at. So we'd encourage you all to read that paper. Let's now go over, let's cross the Atlantic to the US and the Midwest, in fact, which I don't think we've yet had represented in this series. We've had the East Coast and the West Coast, but not the Midwest. Filippo Lancieri, good morning, over there in Chicago. Your research, and the reason we're very excited to hear from you today, explores the challenges of enforcing digital regulation beyond Europe as well as within. And we're very interested, therefore, in your US-based view. I know you have a presentation prepared, so let me give you the floor and we'll make sure your slides are visible on screen. Over to you, Filippo.
Good morning to everyone. Thank you very much, Lara, Giorgio, and everyone at CERRE for inviting me. It's really a pleasure speaking on this panel in particular. I do have some slides and I hope everyone's seeing it. So I wanted to cover briefly 3 key topics on this presentation. One is why I think institutional design is key and why this panel is really, really important. Then of course, cover what I think are the main discussions taking place in the US right now, and finish with a little bit of a discussion on how to rethink the centralization versus decentralization debate that is very important. So starting why institutional design and enforcement are key. I think it's fair to say that interventions in digital markets have so far a history of underwhelming results. Now, if you go only some of the remedies that happen in the EU in competition law, you see that in the Internet Explorer browser investigation, the remedy disappeared for 14 months and no one noticed. And then in the Windows Media Player, the Windows XP N, that was the Windows that didn't have the media player attached to it, sold literally 0.005% of the copies of the regular Windows XP in Europe. And then the Google Shopping case, we had a straightforward neutrality remedy. Google started winning more than 90% of the bids. We are in the 3rd implementation of the remedy, I believe, and it's still under discussion. Google Android's auctions are being criticized by most industry players. Facebook was condemned in Italy for some violation of consumer protection laws relating to data. It simply refused to comply with the order and just being fined 2 weeks ago for not doing anything. Google and Facebook were threatening to pull out of Australia not to comply with legislation there. I mean, my goal here is not to pick a fight with Filippo at all. No, like these are not monasteries. These are gigantic for-profit companies that are running their businesses in legitimate ways most of the time. What I think we have to learn from the past, and why this discussion on enforcement and institutional design is key, is that we should not assume that companies will just willingly implement regulation that fundamentally change their business models. We should always hope for the best. We should always plan for the worst, and planning for the worst, meaning have the right enforcement tools and the right ways to generate information in place in the first place. Sorry. So moving on to the discussion in the US, it's a bit hard to talk about the US as like this gigantic company, gigantic jurisdiction. There's so much going on. But I think you can try to look at what has been some documents that are coming out and how they are seeing this issue and how they are seeing institutional design and enforcement. So it's fair to say that the general diagnostic from both Democrats, Republicans, and pretty much everyone is that the FTC and the DOJ became complacent in allowing these major companies to rise. And the solution now, the discussion is, okay, how do we kickstart enforcement again? How do we improve welfare overall? And the House Majority Report, the solution that they are proposing is to have new and clear rules. So they were discussing structural separations and line of business restrictions, broad non-discrimination rules and interoperability obligations, changes in merger presumptions, structural presumptions for concentrated markets. But these have been, I think, very clearly combined with some kind of new enforcement or renewal of enforcement alternatives. So first, there's a lot of conversations about strengthening regulators. There are proposals to almost triple the funding of regulators. And for those who don't know, the FTC and the DOJ have a combined funding of almost $550 million. And in the past year alone, they hired almost 140 new staff just to address mostly digital markets. There's a lot of new congressional oversight, of course. That's the House Majority Report. If you look at the new Klobuchar bill that was proposed a couple of weeks ago, they talk about strengthening whistleblower protections, which is a very important tool to ensure that the public and regulators discover violations, and also that whenever regulators are not doing the best jobs, that the public discovers this. And we saw this also in the DOJ in the past for important whistleblower alerts. But there's also the embracing, I think, of decentralization. So the House Majority Report really discusses the importance of reuniting private enforcement. So they discuss removing forced arbitration clauses and limits on class action formation, lowering pleading requirements, facilitating findings of antitrust injury, all of these to make sure that private parties can sue alongside regulators as a way to complement enforcement. And we are really seeing a rebirth, I think, a new role for state legislation. So state AGs are leading novel antitrust charges we're seeing here in a lot of different investigations. And there are a lot of new laws that are passing that go much beyond what is expected of federal laws. So California and Virginia passed consumer privacy laws that are the first general privacy laws in the US. Maryland passed a tax on digital advertisement that's going to be litigated. Just yesterday, the Congress of Arizona, State Congress of Arizona passed a new law that would require app stores to have more than one payment method, and these laws are discussed in other places. So I think a fair message that's coming out, and there's a bit of the history of US antitrust or competition enforcement, is that of course it's important to have a central regulator that can face major companies and be in equal terms with them. But there is a risk of putting all your eggs in one basket, as they discovered in the past with the FTC and the DOJ. And so there can be gains to have if you kind of decentralize enforcement a bit. And if you have alternatives for enforcement that also include states or what would be like NCAs in Europe that include private enforcement, I think what Giorgio was saying as well in the P2B regulation. So these are all important gains that can be had from this extra avenues of enforcement. And then I wanted to conclude, and I think we have a lot to discuss, so I don't want to take too much time. Just with a brief way to rethink decentralization versus decentralization. I think we're very used to thinking about enforcement in this verticalized way, which is like one authority does everything. So DG Comp opens an investigation, condemns a company, designs a remedy, and then monitors the remedy implementation. Because there are procedural limitations to think about it. There's historical reasons, it's more practical. But I don't think this necessarily needs to be the case. And when you're thinking about the interconnection and enforcement in digital markets and the interconnection between different regulators, different authorities, we can kind of break down enforcement or remedy design as being the combination of three fundamental tasks. So first, you need to have someone who identifies an illegal conduct or a behavior that negatively impacts welfare. No, doesn't need to be an illegal conduct. Then you need to have someone or an agency or someone who designs appropriate interventions to tackle the problem. And then finally, you need to have someone who oversees remedy implementation. And in particular, in markets where you have extreme information asymmetries, which is the case of most digital markets, this is going to mean a necessary process of adapting interventions over time, because you're going to have to impose initial remedy, see how it impacts the market, what the reaction has been. Then as you get more information, you impose a new remedy, and this becomes kind of like a cycle of slow changes. And we are very used, I think, to thinking about remedy designs like this 200-page decision. Then the final 10 pages comes a general obligation not to do the same thing again. And we don't think it as this process of constant fine-tuning. And I think reflecting this in the legislation, and some of it is reflected now, is very important. And there can be a lot of gains in separating these tasks and allocating them to different agencies. So I think Thomas was speaking very well about the challenges of having interoperability remedies, for example. So why can't you have, for example, DG Comp finding that some type of data is necessary to promote competition in a given market, but then delegating the task of designing APIs, understanding the access, the cost of access to some kind of data protection agency that actually has the expertise. So I think that this can, if we think about decentralization versus decentralization along this, what level of these three steps can be a good way of rethinking the problem a bit, and then opening new ways for cooperation that we are not anticipating yet. And then I'll finish here. I think for those who are interested in this topic, I have a paper. I've been thinking a lot about it, and I have a paper about it, and I really welcome anyone to take a look and read the comments if necessary. But I'll stop here, Lara. Thank you very much for the invite, and I'm looking forward to a very engaging discussion. Thank you.
Thank you so much, Filippo. That was very comprehensive, and your paper indeed looks very interesting. Thank you for that slide with the details. So now I think to seek views from both national regulators and digital businesses, who are of course the key takers who will need to adapt to the new ways of enforcement and institutional designs outlined. We have, so I'll introduce our panel now. We have Anaïs Gouguec, Head of Economic Analysis and Digital Intelligence at France's Arcep. We have Philip Malick, Director of Economic and Social Policy for EU Affairs at Facebook in Brussels. Dragan Jovanovic, Senior Manager for Public and Regulatory Affairs at Deutsche Telekom. And of course, you will be the three lead speakers in this panel, but certainly Thomas, Giorgio, Filippo, absolutely do feel free to chip in. This is an interactive session. The Slido remains open for questions. Please let us know who you are if you can, and if you have a panelist in mind for your question. For coherence with previous sessions, though, I think it would be good to start with helicopter views of the DMA, because then we can contextualize why it's so critical that we get the institutional design right. And Thomas mentioned indeed that this is a central discussion point in negotiations in the Council and Parliament already. So for speakers, can I ask whether you could each please very briefly capture one point of alignment with the Commission's thinking within the DMA as a whole, and perhaps the key aspect of the proposal that you think might need reconsidering negotiations. Dragan, I'm going to come to you first, if that's all right. As a German national telco and one of Europe's largest telecom providers, how is Deutsche Telekom receiving this ex-ante instrument for digital markets?
Thank you very much, Lara. Thank you for having me here and for setting up, first of all, this very interesting, highly relevant event on the DMA once again. So now I come to my view. Maybe a first observation is, and also referring and keeping in mind what Filippo just said about the centralized versus decentralized approach. Actually, we welcome the centralized approach because it best reflects the scale, the nature, and the geographical scope of the businesses. There might be some alternative approaches that would deviate from the traditional point of view of the vertical one Filippo just alluded to. Might be the case, but whatever these alternatives are, consistency across the single European single market and avoiding fragmentation should be the goals, apart from speedy processes, etc., etc. Another point of alignment, maybe, if I may, very good thing, the use of ex-ante nature or forward-looking obligations in combination, or that are paired with the targeted approach that is not a horizontal one, does not address each and every platform, but is really targeted to those platforms that reveal certain identified issues that could not be tackled by existing regulations or competition law in the past. Finally, maybe a word on a potential concern or issue where some concerns may arise. It has been, especially at Giorgio, has been touched upon the updating mechanism used to update the list of core platform services, and also the list of obligations specified under Article 5 and 6 is good per se. It's important to have an updating mechanism there because it's a fast-paced industry, fast-paced ecosystem, needs to keep up with that, such a regulation, in order to be really up to date and relevant. But there are some improvements in terms of the timing. There's a market investigation that takes 2 years. There's maybe also some improvement that can be realized by deepening or creating some form of collaboration with national authorities, either competition or regulatory authorities, to do some experience sharing, best practice sharing, and also complaints that might hint at some obligations to be added in the list of the obligations on Article 5 and 6, or even subtracted. So far from my side, thank you very much.
Thank you, Dragan. Lots to think about there, and this will come up in the questions as we move forward. Anaïs, let's come to you. Arcep, of course, have been very active in the DMA space already, and we're highly aware of France, who will be overseeing DMA negotiations at a crucial time. What are your views on the DMA as a whole? One main point that you like, and maybe something that Arcep is more concerned about?
Thank you very much, Lara. Maybe just a global disclaimer on our position at Arcep. Our view on the DMA is mainly based on the ex-ante asymmetric regulation experience that we have on, although a very different subject because it's on the telco sector and not on digital platforms. And also, as guardian of the net neutrality, which is also part of our job, this can maybe also explain some of our positioning on this issue. So maybe getting back to your specific question, or I would say that a main alignment that we could mention is that, well, first of all, very much agree with the Commission that we do need to get to the next level, and we need to start using ex-ante regulation for gatekeepers, because we've seen in the past that classical competition law was not nimble enough to address the issues we've seen. Actually, we've been advocating for ex-ante asymmetric regulation for years now. As I was mentioning, as guardian of the open internet, we're a bit concerned, especially regarding freedom of choice for consumers. So we see this proposal by the Commission as really a historical step and we very much welcome the proposal. And I think it's an excellent basis for discussion. Maybe one main concern regarding the proposal. This was also touched upon by different speakers before me. There's the question of how future-proof the regulation is going to be. In particular, the Articles 5 and 6, those are based on past cases. And the issue is that it's going to be crucial to be quickly able to react to new practices, because there is a high incentive for gatekeepers to conform in bad faith and to trick the Commission with technical creativity, and they can be very inventive on that. And also there is going to be new products that will appear in the future. And there is a high chance actually that the gatekeepers might be able to succeed in tricking the Commission, because there is a huge level of information asymmetry. So my view is that it needs to be a cyclical work, as Filippo was mentioning. You will almost certainly not get the perfect remedies right in the first time around, and it's not a problem. We need to be open to open the remedies and to fine-tune the remedies, along the way, and also to be very much open to dive into the very technical details if that's needed. And I will stop here for the moment.
Thank you very much, Anaïs. Philip, Malick, over to you. Of course, this will be a piece of regulation that Facebook is looking very closely at. What are your main views?
Yeah, thanks, Lara. Thanks very much to CERRE. I think this is a fantastic series of events exploring all the different pieces. And I think, to concur with everybody else, the devil is in the implementation. And when it comes to the institutional design and the way in which enforcement works, when all the shouting is done and when all the institutional discussions are finished in Brussels, we have to work with a piece of regulation. And so this is why these types of discussions, I think, are very important to approach very early on in how we look at this. I think what's clear from this discussion is that we're approaching a totally new concept of regulatory oversight. Something that is not quite competition law, yet we talk an awful lot about competition law. It's not quite anything but something, but it's internal markets. And so, given that this is a totally new concept, there's a lot of questions that really should be ironed out as we move through these different ways that we look at things. I think the major shift here is a move from managing markets to managing companies. And that really needs to be evaluated, how it works and its practicality going forward, especially with what we potentially foresee as the two main aims of the DMA overall. The first one is to currently or limit the ability of whoever becomes one of these 15 to 20 or 30, however many gatekeepers there is in the end, to continue to carry out business in the way they do today, to impose some limitations on that. But then also an attempt to redistribute some of the efficiencies from the market as it stands today, in the aim of ensuring some element of contestability in markets, which I think some commentators here have said are not able to be managed through competition law. One observation here that I see from many conversations around the DMA, the constituent that gets mentioned the least really is the consumers at the end of the day. And I think this is a really important part of what we need to look at from the DMA. I've listened to a number of discussions which Thomas and a number of his colleagues have had, that the DMA is a tool for B2B intervention. I actually think this has a pretty profound effect on consumers at the end of the day as well, and we shouldn't forget that. And that should be a lens through which we need to interpret some of these challenges and how we're doing that. So also, the questions come around what does success look like from intervention here? What's our criteria for success? If we're going to be in this modality of implementing changes, if we're going to be in this modality of being nimble, we need to know where we're going. if you want to change direction, you need to know a destination. And if that's not clear, then we need to really try and understand what we're trying to do there. So a couple of final thoughts maybe. I mean, although the political impetus is really clear, I think that we need a DMA, and this is something which, you know, we don't argue with, the political imperative is there to get this done. We really think that this, you know, this is something that's going to govern the European tech space for the next 1 to 2 decades. So how do we get this right in its fundaments? And these types of questions are not about, in many instances, the market we're managing today or looking at today. This is about, I think Anaïs made the important point about how do we manage this moving forward in the long term? How does the technology evolve and these kinds of things, and how we build that into this proposal? It's going to be very important. You know, we really see that there's a few sort of key criteria here when we're looking at what we really want to sort of build into this. The first one is foreseeability. And I think perhaps this is maybe one of those things we have to evaluate, and the ability to be flexible. I think companies should be able to have some foreseeability in the regulatory environment in which they operate in. I think that's really hugely important for investment security, for legal security. And so that foreseeability point is really hugely important for us. One which has been hinted at here, but I think is a kind of I think Giorgio brought it into the discussion really well, is this ability to have dialogue. It's the Article 7 process within and those of us in the telecom space will recognize another Article 7 process, but the one in the DMA here is, you know, it hints at a dialogue on Article 6. I think a broad dialogue for compliance is, you know, necessary for any company, given the variety of business models companies are in, that compliance needs to be understood in each of these companies' perspectives. And so a dialogue overall, and having worked in regulated industries for a very long time, I have not known a regulatory environment that doesn't involve dialogue in a very practical way with the regulator. So hopefully that's not something that's too controversial, whichever way regulation is managed. And the final one, which I think is a uniform sort of view across here, is definitely harmonization. The DMA has to function on a single market basis. This is paramount for the way in which I think the DMA will be deemed as a potential success or not, is the way in which it incorporates the values and also the power of the single market overall for investment and for innovation. So they're just my first reflections, I think, Lara, on where we stand. But yeah, again, really looking forward to the debate and the discussion.
Thanks so much, Phil. And actually, I think you set the scene really nicely for us moving to more focused questions, because I was going to come indeed in the first instance to regulatory dialogue and culture change. I think it's been broadly, there's some broad consensus around the fact that this will be crucial to enable an optimal method of centralized enforcement. I already mentioned CERRE has done some dedicated reflection on new ways of oversight in the broader sense within which enforcement falls within this continuum. But let's maybe have the panelists' views on the more comprehensive culture change that might be needed to enable centralized enforcement. Maybe Anaïs, you as a national regulator, you'd be well placed to come in first on this one, and Thomas, maybe after that. I'd also love your views on this. Thank you.
Thank you, Lara. First, I would say that what I think is quite important is that in the DMA, what we need is to discuss with all the parties that are involved. Because here, the purpose of the DMA is to design remedy to benefit SMEs and consumers in the end. And I believe they should be able to be heard in the design of the remedies. It's a highly technical industry. The Commission is going to need all the help available to build a critical analysis of how the gatekeepers are conforming to the obligation. The devil is in the details, and in particular, I'm thinking of interesting points, for example, that were made by DuckDuckGo regarding the concrete Android remedies. You can see here that there's a lot of technical leeway to nudge consumers in the direction you actually want them to go. So one idea, for example, could be that you could request of a public restitution also of how the gatekeeper intend to conform to the obligation, with the possibility to comment, the possibility to alert the commission also between every 2 years round where the gatekeeper status is reviewed. Regarding also the cultural change, I think it's a very important point that we need to discuss, because as Thomas was mentioning, this is very different from competition law. This is not the same logic, and this also entails a very deep cultural change. Right? If you really want to shake off the limits of competition law, what you need, I think, is also to stop thinking your action in terms of punishing behaviors. That's a very huge cultural change from competition law, because sanctions, they are very important. They are absolutely paramount if you want to make sure that your decision is going to be respected. And as Filippo was mentioning, this is a very, very important point. But this is not the core business of ex-ante regulatory framework. I mean, sanctions, they are costly. They are costly financially for the regulated actor and politically for the regulator. They require a high standard of proof and due process, and as it should be, given the fact that the stakes are very high. But the lifeblood of ex-ante regulation is remedies, really. You're not here to punish someone for wrongdoing. What you're simply telling them is, okay, you just have to stop doing things this way, and now you're doing that in a different way from now on. It's much nimbler and more operational. It's a very different spirit, and I think it also connects to the point that that Philip was mentioning regarding foreseeability. I mean, here you're building new remedies, and you're not evolving with the risk of having a huge fine just coming on your way. So the foreseeability is also in the building of the remedy with the Commission. This is also making me think of a mechanism that we have in the telco sector, which is the dispute resolution mechanism, which is very much in the same spirit. In this situation, you have two actors that disagree on a very specific point, and they come to you. And you're not here to punish anyone over the other, but you are here to set the way forward, to clarify how you interpret the regulation in this very specific case, possibly even simply acting as a mediator between the two. And I think that's a very illustrative of the difference of views on different culture. But for all of that to work, the problem is that you really need to be able to specify very concretely what the remedies entail. You need to be able to get your hands dirty and digging into the technical aspects if needed. I mean, some of the obligation in Article 5 are very straightforward, and they don't need they don't require really a lot of technical digging to be workable. But a lot of other obligations really need, and as you were mentioning, Thomas, in particular, everything that is linked to data portability and interoperability. This is clearly the ones that are going to require a lot of technical digging. And you really need to make sure your remedy is really fit for purpose, that challengers are going to get the full benefit of your remedies. And that requires trials and error, because this is also a very new sector. I mean, there's experience that has been built with the past cases that were dealt by the Commission. So and that's great that the Commission is not starting from scratch, luckily, but still there is going to be some learn by doing, and that's fine. And that's, I think, as I was also mentioning, another cultural change here, that remedies are not set in stone. As long as you respect the spirit of the obligation to ensure some predictability, it's okay to change your requirement of how they are applied by the gatekeeper if you realize that what you've asked in the first place is not really bringing you all the results that you were hoping for in the first place. And I will stop here.
Thank you very much, Anaïs. Very comprehensive, and like Filippo in his presentation earlier, that the focus on remedies is very clear as something to think about. Thomas, if it's all right, we'd love to hear more on the Commission's views on the culture change aspects, perhaps. In particular, you touched upon regulatory dialogue in your remarks, but how does DG Competition see the culture change needed to make this work?
I think there's not much I can add to what Anaïs said. I think she described it quite well. This is a regulatory approach. This is not competition law, as I said before, so the approach will have to be different. It's also a repeat game. No, you see your clients much more often than you do in competition law, where you have one-offs and then you hopefully think the things are settled. But here, that's why you need the dialogue. I think it makes a lot of sense. We tried in Article 7 to provide for such a dialogue. Whether this is enough, I think the legislative process will show. But one should also, and what is very true, that the focus here is really on effective remedies and not so much on punishing the companies. I think I very much agree. The real purpose of the DMA is to come out with effective solutions to the identified issues. But one word of caution, obviously, the carrot and stick approach also needs a stick once in a while. The carrot is very fine, but with large companies and there, I think our experience from competition law is valuable. If you don't have the stick once in a while, then you can't ensure compliance, and the best carrot approach will not lead to anything if once in a while you don't show your stick and show that you can also enforce if it's necessary. So you need both. I think the DMA has both. They're very strong enforcement in terms of ensuring compliance, in terms of penalty payments, which are probably more important than fines even. But there's also the carrot approach in terms of the regulatory dialogue. I think it needs to be a mixture of both. The Commission is in a way lucky that we have both experiences. No, we have the experience from looking into telecom regulation through the Article 7 process, which our colleagues in DG Connect do mostly, and where DG Comp was also involved, or is still involved. And we have our experience from the competition cases. So I guess we would try to combine the best of the two worlds and draw the experience from both in order to devise a carrot and stick approach that works properly.
Great, so best of both worlds and complementarity rather than perhaps with some elements of dividing and conquering. Thank you, Thomas. Dragan, over to you.
Sure, thank you very much. Maybe two quick points. As has been said before, there are already several elements and aspects, right, that allow for regulatory dialogue between the regulator on the one hand and the parties on the other hand, right? Either in a designation phase or by designing or specifying certain obligations under Article 6, etc., etc. This goods could be certainly strengthened and expanded on, depends, but just reminding again everything that would happen there in terms of expansion, of strengthening or changing things up. Would need to adhere or follow the main goals, right? And the main goals are to come up with something that is effective, that is quick, swift, and speedy, and not simply adding elements that would reflect the regulatory dialogue for the sake of having a regulatory dialogue, right? There's just a word of caution here on that sense, in that regard. And a second point I would like, and there I fully also agree with Anaïs. The regulatory dialogue does not stop with the parties, right? It also consists on other stakeholders, right? There are avenues and there are possible channels, opportunities to exchange information, experiences, best practices, etc., with the national competition authorities and other authorities there that are relevant to the issue at hand. It's welcome to that regard that the Commission explicitly allows designing remedies and other instances to consult and use external experts and auditing there. So it includes a lot of relevant players, which it should, given the complexity of the ecosystem and the market themselves, and of certain also when designing remedies, right? The best experts, people that fit could answer certain questions or present solutions to certain issues should be also utilized, right? But as I said before, that should not lead to a sacrifice of effectiveness, time, speed, and everything. That is the overriding principle here, and everything should be assessed under these overriding goals. So far from my side.
Thank you very much indeed, Dragan. Phil, now you covered quite extensively both changes of culture and the need for dialogue in your overall intervention. But if you have anything quick to add on this, I still want to make sure we get the chance to hear you.
Yeah, I'll be quick, as I said. I ran through most of these. I think the fact there's 18 obligations applying to potential multiple core platform services amongst different companies with different business models, again, just to reinforce, you know, the kind of dialogue light provision in Article 7 now, which just applies to some of the Article 6 areas, and the Commission actually in the legal text has actually, it doesn't have to reply. It may reply. I hope, you know, Thomas can maybe say we will reply, but at the minute that's not in there very clearly. Listen, also on this idea that the remedies are iterative, I think a really important thing to bear in mind is a lot of these will require pretty significant changes to companies' potential sort of business models, structures, products. So that foreseeability also needs to play into the fact that I think we hope that, you know, every 2 years companies aren't asked to, you know, redesign the business, redesign the product, redesign the consumer experience, and that, you know, dialogue doesn't mean kind of wild fluctuations in the way in which implementation is carried out. I think that's a really important thing. For the companies don't have to kind of re-implement provisions every 2, 3, 4 years, and that actually, you know, this dialogue doesn't kind of push us in that direction. And also because, I mean, this process now doesn't need evidence of harms, right? I mean, we're away from that. We said this is away from competition law now. And the penalties for non-compliance, although Thomas and also Giorgio have talked about, you know, the need for this pyramid approach, the stick is there, and the stick is big and heavy. And at the end of the day, we think companies just deserve a fair chance to comply, given that those two kind of ends of the spectrum are there.
Thanks, Phil. That's very helpful. I think another thing that we have already touched upon, but I think it would be important to gain panelists' views on is on this question of aspects of cooperation with the member states, which is a key part indeed of regulatory dialogue and on oversight. It's been clear from all remarks so far that if centralization is to work effectively, we need national regulators to align and cooperate. Thomas, in his remarks, also talked about data protection authorities, you know, GDPR. There are a number of alignments with existing digital regulation at European level that come into play here. So one question, I think, on the DMA specifically is, as we're looking at the institutional design, do we need national contact points to align among all the different national regulators? I mean, Anaïs mentioned the net neutrality and telco guardianship of Arcep, for example, vis-a-vis the national competition regulator. So are national contact points, like we have in some other EU instruments, an option? And if we go down this route, what could these national contact points do? Perhaps, Phil, I'll come to you first on this one. What do you think?
Yeah, look, I think this is potentially an opportunity cost that's paid by centralization, that your ability to diverge nationally is impeded. There is a way in which member states are interacting within the DMA in a kind of consultative manner in a number of ways, but you know, I think in the seeking of harmonization, it's difficult to sort of manage things in something particularly in a pretty complex way. So national authorities are hugely important, because I think potentially a lot of the people in taking some of these remedies will be maybe on a more national level than a pan-European level, but we don't have answers to that, because I think it's an enormously complex potential system to be built there.
And Anaïs, what would your views on national contact points?
Yes, on that, I think, well, first of all, we believe that the right level of intervention is the European one, because contrary to what you have in the telco sector, for example, it's really rarely really national specific issues. It's much more broader in general. Yet, we do believe that there would be a use of national authority, especially given that, and maybe we will get back to this issue also, but the question of the firepower that is needed for the Commission to really do their job. Because right now, I think it's 80 FTEs that are considered for the regulation in the near term, and I mean, I think it's probably too low. You can compare that to the CMS proposal that for a similar kind of regulation, they are thinking of 300 people, and they have only one country to look at, and not 27 like the Commission is going to have to do. And in general, the Commission is going to have to be able to actively challenge the gatekeeper's proposal, and that requires a lot of firepower. So on that, first of all, I think the 80 FTEs is probably too small, but on top of that, I think the Commission could use national authorities to help have a bigger firepower. National authority could indeed act as local branch for the, or so we can say, for the European Commission, because first of all, I believe the SMEs might be quite intimidated to go directly knock on the EC's door and to complain about the behavior of the guy that could actually crush their business within a week. So it might be less intimidating for them to go and discuss with local actors. And there's also, and we can still consider that, I mean, even though it might look stupid, but there's also the language barrier. In any case, the national relays could help to inform SMEs of their rights under the DMA, to help them check if they have a case that actually needs to be really reported back to the European Commission. They could help also to monitor the market and to feed the Commission with information regarding new practices. Possibly also take care of dispute settlements if you have small enough cases, and etc., etc. And in any case, I think having sufficient means to achieve the DMS ambition is especially important since, I mean, Giorgio was mentioning that in the list of actors to watch is short. It is short, but it's not that short either. I mean, there's a lot of products, a lot of business models that are, so it's going to be a lot of work for the Commission. So there's also the risk of the Commission's resources being scattered. And so as much the Commission can get help, the better it is.
Thank you, Anaïs. Giorgio, I know we've discussed a lot within CERRE before, this question of staffing and even whether AI, for example, and other technologies could help plug that gap or increase the firepower, as Anaïs puts it. Do you have any thoughts there?
I mean, obviously, there are ways of monitoring compliance which can be automated. And I think here there may be some national authorities that have a comparative advantage, and so it'd be useful to take advantage of that. So in the CERRE report, we recommend perhaps seconding staff from relevant authorities that might have such knowledge to the Commission, might help strengthen the Commission. So that's another way of liaising between them. Perhaps more generally on the relationship between the regulators and the Commission on this. At national level, we've seen that because issues in tech markets overlap between regulators, data protection agencies, and competition authorities, cooperation protocols have been developed to facilitate coordination between authorities, information sharing, and so on and so forth. So I think a similar model, which can be done by soft law, should be encouraged also here, whereby you have an idea of how different bodies respond. Lastly, we also have some precedents under EU merger control where a remedy is the enforcement or the design of the remedy is delegated to a national regulator. So in some telecom cases, you ask for spectrum divestment to be done by the national regulatory authority. So I think the precedent, as Thomas mentioned earlier, of using the national regulators or competition agencies when they have powers already to either implement a particular remedy or assist implementing a remedy is plausible, because in a sense, they already have the legal authority to do so. And I think that can help, make enforcement more accurate, also because you rely on the national knowledge in order to design the remedy. Thanks.
No, thank you, Giorgio. And interesting too that you're talking about soft law complementing the regulation, perhaps guidelines or other methods there. Dragan, as a national telco, I think this is an important question to put to you too. Do you have any views?
Sure, I agree with Anaïs on the staffing issue, right? But there are several avenues, right, or possibilities how to tackle the issue. One possibility or option is to cooperate, to deepen the cooperation with national authorities, exchange expertise, maybe even what Giorgio is also suggesting in the paper, right, via secondments, etc. That is quite helpful. What you mentioned, Lara, is the more technological oversight that has been also discussed the last CERRE event. Also very interesting, right? Because there, some of the issues, the staffing issue, reveals could be partly at least mitigated, right, by automatized interventions and ensuring also quick, speedy, and by design action by the authority. But it won't do the whole job, right? It won't solve the whole issue. So it must be a combination, I guess, that ensures deeper, strengthened cooperation between national authorities to some extent, where they are following a role of a supporter, supporting in terms of expertise, evidence, and experience, of course, and the use also of smarter regulation, I guess, instruments would help there again. There are several constellations that are conceivable, might be considered, but in the end, it should be always the one. It's quite easy, although very complicated, but easy in the sense should be always the one that does not endanger, but helps the consistent application and effective application and enforcement of the DMA, and avoids fragmentation and all the deficiencies and shortcomings that have been identified in the past in association with existing rules and competition law. Thanks.
Thank you. Filippo, I know you wanted to make a comment here. How do you see it from the US?
Sure, it's a very brief comment. I really like an expression that Anaïs used, which is to feed information. I think we need to understand that the biggest challenge of a mechanism like this is that the extremely large information asymmetries that you have between industry players and regulators. We are used to thinking like the trade-off of centralization is higher risk of capture. Now, I'm from the Stigler Center, I have to use the words. We are used to think about capture as like, I don't know, people giving cigars to this to people at Digicomp, but that's the wrong view. The right view of capture is that there's so many information asymmetries that the company can kind of convince the regulator that what the company is doing is the best thing. That's in the public interest, and the regulator goes along it. And so the biggest challenge of the whole system here is, so regulatory dialogues, coordination of NCAs, all these discussions is how do you create an ecosystem where the relevant information is generated and brought to the decision maker so the decision maker can make the right decision. So if you have a dialogue where you involve companies, so that DuckDuckGo, who knows much more about search than any official or than anyone studying this market, can come in and say, hey, this Android screen doesn't work because you're going to be gamed because a small search engine who makes a lot of money per click is going to come ahead of me. And we can incorporate this information, then that's good. If the regulatory dialogue is just a way to delay decision making or to do whatever, then that's bad. Same thing about NCAs. If the NCAs can be used to bring information, as Anaïs said, have a small company, a small SME, go first to the French agency, then the French agency kind of filters this information, brings it to Digicomp. That's great. If the cooperation is just a way to put everyone in the same room and give them a small voice, but then ignore what they say in the end, then that's bad. I think that the central topic here really is, how do we create an ecosystem to generate the kind of information that you need to make good decisions? And then all of this discussion should have this as the ultimate goal that we should be talking about. So that's what I wanted to add.
Thank you very much, Filippo. Yes, feed information is definitely a catchphrase we should maybe use more in these debates. Thank you. Thomas, if you'd like, do you have anything you'd like to add?
Yes, very briefly. I think when it comes to involvement of member states and national regulatory authorities, I think two levels of answer are required here. First, there's the decision-making process, and then there's the knowledge pooling. I think these are two different things. On the decision-making process, I think we are very firm that we still think that the centralized approach with one decision maker at European level makes more sense. On the knowledge pooling, I very much agree that the more knowledge you can pull from different sources, the more you can rely on expertise from different sources, the better the decisions are going to get. So I think there is need, as I said before, there's need to involve data protection authorities, national regulatory authorities, national competition authorities, just to pool the knowledge. And as many people have said before, there's large information asymmetry. So the more knowledge you can pool on the side of the regulators, the better the decisions are going to be. Just one brief comment on the 80 FTEs that have been discussed forth and back here on this panel. I mean, 80 is obviously, it's a first budget that the Commission has put forward. It's the core team that will start with the implementation of this, but obviously the Commission as such can draw on many more resources. We have the Joint Research Center, we have a whole DG with more than 1,000 people in DG Connect who deals with digital markets on a daily basis. So we have a big pool of in-house resources which we can draw on. So it will go beyond, and there's the chief economist teams in DG Grow, in DG Comp, which one can draw on. So a lot of information that the Commission has in-house, specialists on the GDPR, for instance, in DG Just, which can help us. So it's not that we would be limited to the 80 FTEs that have been budgeted as the core team for the DMA. I think the Commission as such, as an institution, can draw on a lot of resources. If that is then pulled together with a lot of knowledge which is in the national regulatory authorities and competition authorities, I think there's a big information pool or data pool, if you want, on which one can rely in order to make good decisions in this process.
Thank you so much, Thomas, because I think that's a question that's come up throughout these debates. So understanding where the Commission's at on understanding that it will deploy resources throughout the institutions is very helpful to understand. Thank you. Now, time is flying. There is another question I would like to ask you also. I think let's do it as a quick whip round, and perhaps you can include any concluding remarks you might have on this. I do have a question from a viewer that I will put to you as well as part of this round. So I appreciate there'll be a few questions in one, just to see how you'd like to build it in your intervention. So viewer Freya van den Boom asks what the speakers think about restrictions coming from free trade agreements. It's a new angle we haven't explored yet in this webinar series. And I think what I wanted to ask as a last round here was something that came up in the initial interventions from Giorgio, Filippo and Thomas, in particular, which was on market investigations. Because indeed, as Thomas said, this has perhaps been under-discussed in the first round of debates as Brussels digests the Commission proposals. But what do we think in terms of the sort of commitment value of a market investigation? Is there any extent to which a market investigation might be binding evidence underpinning Commission decisions? So if you have any further comments on this, this would be very welcome. Dragan, maybe I'll come to you first on this one.
Sure, thank you, Lara. Sure, maybe on the market investigation issue, it just has been emphasized the role of information gathering and somehow bridging the gap, information disadvantage in the gap that the regulator faces vis-a-vis the parties, the gatekeepers to be regulated. Market investigation in that sense plays a certain role because it clarifies certain issues that where there might be a controversy maybe for instance in relation to designating gatekeepers, and it is also used for instance to design remedies in case of systemic non-compliance. There are also several other use cases for the market investigation issue, but in regards of the remedies to be designed and used in case of systematic non-compliance, my question would be, okay, the market investigation serves as an evidentiary basis for the Commission, but what does that mean in detail, right? are the remedies then that are proposed by market investigation, right? That will take a certain period of time, gather also experts, gather relevant evidence to come up with certain recommendations and suggestions that are, of course, in best case effective, or the best instruments at hand to solve the issue, present issue. To which extent is it actually binding for the commission, for the commission's final decision? I mean, or is it just one, let's say, one piece of evidence that is used alongside others, alternative ones? That is at least not entirely clear to me, and that needs to be clarified. In general, it serves certainly to improve decisions made by the commissions in several instances, because its goal is in the end to produce relevant evidence that will lead to better evidence-driven based decisions. So far so good. Maybe, and on the free trade agreement issue, there is actually no specific view, because could be debated for 2 or 3 hours very generally, but no specific view there. Thank you very much.
Thank you. I think on the free trade agreements as well, it's likely to evolve over the coming years, also even as the DMA is being negotiated. Phil, how about you?
Yeah, thanks, Lara. I'll be really quick. I think I echo Dragan's comments here, which is also the powers which are then in place potentially around things like new merger notification procedures, product development notifications, these kinds of things. I think the question is kind of, where does it lead? So what's the end game of these procedures? To Dragan's point, is it about informing enforcement? Is it about binding enforcement? What's the process, and how do we kind of foresee that kind of concluding at some point? Where does it conclude? Again, foreseeability, hugely important for companies when they're involved in these processes. I won't, because I know we'll push for time. On the free trade agreements, yeah, I'm going to dodge this like Dragan did as well. I don't know. But I'm sure many trade experts could kind of mull over this for a very long period of time.
Something we'll have to think about for a future webinar. Thank you, Phil. And like feed information, I think foreseeability is definitely a catchphrase I'll take away from this discussion. Thank you very much. Anaïs, on market investigations and any closing remarks you may briefly have. Thank you.
Yeah, maybe a more general point on market investigation. The way I understood it, it's the main source of flexibility for the DMA text. And I wonder, I have no firm answer actually on that, but I wonder if it's a nimble enough instrument to update the Article 5 and Article 6 list. And I was wondering also, would a case-by-case assessment remedy mechanism be, I don't know, maybe more adapted for future-proofing the DMA? That's also an open question. If I remember correctly, that was also one of the leads that were considered by the Commission back in the days when they were drafting during the public consultation before drafting the DMA, I think that would be, in general, is that my main global comment would be that we're going to need to be very flexible, actually, and to the Commission being able to respond very quickly to and efficiently to all the issues that are going to arise, because this is a very fast evolving market, and there is a lot of creativity on the side of market players, and so we need the Commission to be sufficiently backed to have the possibility really to tackle efficiently all the issues that are going to arise, and it's going to be a tricky job for the Commission. So I hope I hope them well, but it's going to be a tough job.
Okay, great. Thank you, Anaïs. And with the spirit of wishing the Commission well, let's start maybe on the sort of conclusions from Filippo, Giorgio, and Thomas as our lead presenters. I mean, maybe zooming out on wishing the Commission well, Filippo, it could be good to start with you here.
Sure. I mean, I cannot comment on trade agreements, and I won't comment on the specifics of the binding nature. I must say that when reading the DMA, I didn't really understand what exactly is market investigations adding to the whole scheme. No? So you can imagine market investigations doing three main roles. So first, they help you gather information. Two, especially in the UK, they help you get out of some legal requirements so you can impose remedies without having to establish liability. And three, they are an enforcement tool. It's incredibly annoying for the companies to be 1 year providing evidence. And there's some people talking about Microsoft in the US that the main remedy was the trial because you put Bill Gates to depose for a long time and then he just says, oh, I don't want to deal with antitrust anymore, And then in terms like, they have a lot of powers to gather information outside of market investigations anyway. So like they have these powers. Maybe the market investigations open some new room, but it's not very clear what. The DMA itself is a way to impose remedies without finding liability. So it's not like we need this scapegoat of the legal obligations. And then it's just a very poor enforcement tool. It's very costly. It's not well targeted. Like annoying companies is not the main goal of the regulation in the first place. So I think that it's interesting to think about market investigations, like what exactly do we think they're gonna add? And if the only goal is to update the regulation, then maybe you can have a more like precise tool that doesn't require a gigantic investigation of years and procedures and things like this. But I think I can comment more in principle than the specific how it's going to impact EU law, because I'm not an expert in that. And I'd love to hear from Thomas about it, actually, what he thinks is the purpose of the market investigation. Thank you very much.
No, thank you so much to you, Filippo, also for joining us. And as you said, you'd like to hear from Thomas on this. Let's smoothly pass over to Thomas. Thomas, again, thank you for being here. It's really added a lot to this series to hear from the Commission. Do you also have any, as well as market investigations, any key learnings from this panel or anything you'd like to say as your closing remark here today? That would be great to hear from you. Thank you again.
Yes, so briefly on the market investigation, I think it's a very interesting, a very powerful tool. I don't think it's a tool that one should neglect. First of all, it provides the flexibility, as Anaïs said. It's the tool that allows the Commission in this DMA to properly go into the ins and outs of markets and to basically verify some of the assumptions that have been taken in the DMA. If you look into, for instance, the rebuttable presumption on who is a gatekeeper, this is the way out for the companies to show that they are in essence not the gatekeeper, and it's for the Commission then to establish by means of looking into the market, digging into the ins and outs of the market, whether there really is a gatekeeper or not. And when it comes to adding new practices, I mean, this shouldn't be done lightly, to add a new practice to the Articles 5 and 6. In the first place, it should be done by the legislator. So the legislator should make the trade-offs. But if there needs to be an update, I think it should be preceded by a very in-depth investigation of the pros and cons of adding another obligation. Just to basically what the legislator should do now should then be repeated on the regulator side. The regulator should go through an in-depth assessment of all the pros and cons and find out whether an obligation merits to be added or not. I think it's only fair that this is done on the basis of a very thorough assessment of the markets before it's put into law. So I think it makes a lot of sense to have these market investigations, and they can be done in different ways. I mean, some of them will focus. I mean, the one on the gatekeepers will focus on the market situation. The one on adding Article 17, adding more new practices, will obviously focus on potential harmful conduct and what are the advantages or the disadvantages of adding such a provision to the DMA. So I think they have different uses, but they are overall a very useful tool. So then, just to conclude, I mean, the Commission has made a proposal. The journey has not yet ended. I think we're just at the beginning of the journey. A lot of useful ideas have been uttered here, and these conferences are, I think, for us also very useful because we learn a lot about different perspectives. There's also a listening exercise. Mostly the ball is now in the camp of the legislator, so we're just facilitator. But hearing all the different views obviously makes a lot of sense, and I'm sure it will also be feeding into the legislative debate. So thanks very much for having me.
All thanks to you for accepting our invitation, Thomas. Thank you so much. Giorgio, final word to you before I close.
Thank you very much. Just one quick intervention on market investigations. I think the term is maybe a little bit overly broad for what it actually is, because as Thomas said, they serve three very discrete functions and they don't really go beyond that. So the precedential value, I think, is limited beyond limited to the scope they cover. One small suggestion I would make is that when an investigation is carried out for systemic non-compliance, the DMA provides that the parties can still offer commitments at that stage. So it's as if this regulatory dialogue can continue forever up until the last bit. And I wonder here if we want to take, as somebody said before, at the end of the day, the regulatory enforcement pyramid has a big stick at the end. Whether having the ability to make commitments, even when there has been systemic non-compliance, which appears quite egregious the way it's defined, maybe taking away the commitments option there might be optimal, because then the party would really be forced to comply well ahead of systemically non-complying. And I think that might improve the regulatory structure a little bit. Thank you.
Thank you very much, Giorgio. And thanks again to all viewers for your attention. I think this has been a truly elaborated conversation. We know that institutional and design and enforcement methods in the DMA will be a pivotal topic in negotiations. Thomas has alluded to it as well. So we're very glad to have had the opportunity to explore this in depth. The next event in this rendezvous series will actually be on the DSA, and that's on the 29th of March. And then we'll announce a high-level closing event for the series soon. Please don't forget, CERRE is also producing studies on many other topics. Next week is Mobility as a Service Week, so looking at the intersection of transport and tech. Our first mass event on the Monday will feature an interview with Transport Commissioner Valean, a second on the 11th where we examine digitalization for multimodal mobility strategies. We'll publish our liability and AI study on the 18th of March. So a lot going on here, and we couldn't make all these events around our studies happen without the incredibly heavy lift of the CERRE team and so many fantastic speakers willing to lend their time and expertise to inform these debates. So many thanks again from me, and see you all next time. Have a nice evening.